In the previous three lessons, we've been talking about the three certainties. We began, should I say, by talking about the certainty of intention. We then followed this on by looking at the certainty of subject matter. And then finally, we talked about the certainty of objects. The three of these referring to, of course, this idea of there being an expressed intention required for the creation of a fixed trust, or at least an express trust. The clear property has to be outlined in terms of what is and what isn't part of the trust in terms of property. That represents the certainty of subject matter. And then finally, there is, of course, the certainty of objects, who may be beneficiaries of the trusts. This lesson is going to talk about a little bit more about the certainty of objects specifically, and focus on this idea of the fixed trust versus the discretionary trust. We'll talk about the fixed trust in this lesson, and then we'll talk about the discretionary one in the next, because ultimately, we made it clear that in the certainty of objects, there is a requirement of the existence of beneficiaries, and that there has to be a certain amount of conceptual certainty as to whom is and who isn't a beneficiary. We're going to talk about the application of the certainty of objects in this lesson with reference to this idea of the fixed trust. So, to begin with, let's think about what the fixed trust is, because we have talked about this earlier on in very early lessons on the law of trusts, talking about the different types of trust that exist. But essentially, a fixed trust is one in which the property and the beneficiaries and the distribution of said property is clearly defined. Okay, so when it comes to establishing the certainty of objects, specifically for a fixed trust, the general rule is that a fixed trust requires clearly ascertainable beneficiaries. So if I was a settler and I wanted to put some money on trust for whoever, for a beneficiary, okay, I would have a clear amount of money that I'm giving to a trustee, and that trustee is going to hold that property on trust for this beneficiary or beneficiaries, and there is a clear delineation as to how that property is going to be distributed, what is going to be done with that property. All the trustee has to do, essentially, is hold on to it, keep it, don't do anything with it, don't mess it up, and allow for that property to then be retained by the beneficiaries on trust as and when they so choose, or maybe even after a period of 10 years, for example. All of this would represent something of a fixed trust. And given this, the general rule, as I've said and as stated here, is that there has to be clearly ascertainable beneficiaries. There must be what is known as a complete list of beneficiaries, as we noted in the previous lesson. Now, one of the interesting cases here is this case here from OT Computers Limited and First National Tricity Finance Limited from 2003. Ultimately, in this case, the claimants had been the retailer of a number of computer products in the late 90s and early 2000s. In 2002, there was an instruction by the claimant to their bank for the creation of two trust accounts. They made two lists. They made a list of customers, and they then made a list of suppliers, following it so far. When the bank sought to discharge these accounts, it was taken to court, and it was held that with the customers, it was held that there was a trust that had existed. But the supplier's account failed to create a trust owing to a lack of certainty of objects, because this was an account which was titled, quote, urgent suppliers, and it was held that the word urgent created uncertainty in the complete list test, and therefore was unable to be drawn up. Because I could have a list of suppliers, and if it was just a list of suppliers full stop, and it was just every single person who has been a supplier for my company, whatever, for the duration of my trading, okay, this would be a conceptually certain identifiable list of beneficiaries, and therefore constitute certainty of objects. But the fact that they had a caveat, essentially, which was not just all the suppliers, but only the urgent suppliers. Well, what counts as urgent? Who defines what urgent may be? For some people, urgent suppliers might be this list of suppliers over here. But for other people, urgent suppliers might be this list of suppliers over here. Where is the line drawn? This is where the conceptual uncertainty is created, and therefore the complete list is unable to be drawn up. So there was a complete list of suppliers, which is fine, in the same way that there was a complete list of customers, okay? But they didn't have a trust which defined the beneficiaries as just being suppliers. They had a trust which defined the beneficiaries as being urgent suppliers, which is therefore not a trust because there cannot be certainty of objects. Finally then, when we talk about fixed trust, there's one issue here when we talk about certainty and uncertainty. We've focused on the idea of conceptual certainty, the idea of a list being conceptually certain or uncertain as to essentially clearly delimit where the trust instrument begins and ends, essentially. But what about the difference between conceptual and evidential certainty? Well, the idea of evidential certainty is required only for the creation of the expressed fixed trust. And the reason for this is because a trust could fail on the basis of evidential uncertainty, because that there may be an impossibility in the acquisition of information pertaining to who the beneficiary is. So a trust instrument may be completely conceptually certain in being able to clearly define the class of beneficiaries, okay? And there is no conceptual uncertainty there at all. But then when it comes to actually applying and implementing the trust instrument, it could be the case that, well, we have conceptual certainty. We know this list is a complete list. It fits the complete list test, but it doesn't quite fit the test for evidential certainty because it still may be impossible to have an acquisition of information. The case example from Haley and McCurdy from page 81 specifically is that, for example, if we were to have the beneficiaries of the trust be a complete list of first-class graduates from the University of Lincoln in 1967, okay, that would represent a complete list. We can clearly ascertain who is and who isn't a member of that class. It is anybody who graduated from the University of Lincoln, for example, in 1967 and who got a first-class degree. Easy. But then what if that list was destroyed in a fire in 1969, okay? Well, we have a complete list, because we can say, well, who are the beneficiaries? Well, it's every first-class graduate from the University of Lincoln in 1967. Oh, great, complete list, certainty of objects. Okay, then let's start going about implementing the trust. Okay, let's start ringing up every single first-class graduate from the University of Lincoln in 1967. Let's find them. Oh, there is the list itself was destroyed in a fire. Oh, well, it's impossible to acquire the information of who are the first-class graduates from the University of Lincoln in 1967. This is what we mean by evidential uncertainty. And this is really where we see that there is a sufficient amount of conceptual certainty, but there is no evidential certainty because we don't know who makes up that class because we lost the list, for example. And so it has to be very clearly delimited between this idea of there being a conceptual list, a complete list that is conceptually certain, but that it's still impossible to execute the trust on the basis of there being an impossibility of acquisition of information pertaining to who may be a beneficiary. In this final lesson examining the three certainties for the law of trusts, we're going to move away from our understanding of the fixed trust, which was what last lesson was exploring, and start to talk about the concept of the discretionary trust and how the three certainties are applied in that regard, specifically the certainty of objects, owing to the nature of the beneficiaries that are cited in a discretionary trust system. So, ultimately, if we turn back to previous lessons, we noted that essentially what a discretionary trust is a trust instrument. So we have a settlor that is transferring property to a trustee for the benefit of some beneficiary or some class of beneficiaries. But there is a certain amount of, as the name suggests, discretion that is given to the trustee when it comes to the distribution of the property shares to the class of beneficiaries. That's where the concept of a discretionary trust comes from. This is compared to, for example, the idea of the fixed trust, where with a fixed trust you have a clear class of beneficiaries or a clear beneficiary, and there is no room for the trustee to distribute that property in any way they see fit, but in a way that is prescribed by the trust instrument specifically. In a number of cases, the idea of a discretionary trust often denotes something where there is a large collection of beneficiaries. So there's not an expectation in those cases that these shares will be distributed equally. And this is really where we get to the different kinds of distribution when it comes to different kinds of discretionary trusts. And one such example is the case of McPhail and Dalton from 1971. In this case, you have the settlor who establishes a trust fund, which would be for the benefit of his employees. Ultimately, this was a discretionary trust, and as a result of which, the property being held on trust by the trustees were instructed to distribute the property, quote, as they saw fit. So there is a certain amount of discretion that is given to the trustee in terms of distributing the property. Very, very simple. And what is important in this regard, therefore, is that when you have a situation like this, there is a certain amount of power that is granted to a trustee in doing so, in being able to distribute said property. But comparing this to a power versus a trust, you have to obviously make it very clear that with a power there is the ability to default on this authority, but with a discretionary trust there is not that same ability to do so. A discretionary trust requires there be an obligation for the trustee to actually distribute the property. There is an obligation to do that, but the where the discretion comes in is how that property is distributed. Now, the question of whether or not a trust existed was the question of whether or not it could exist without there being a complete list of names. So if you think back to the previous lesson, there was this idea of to satisfy the certainty of objects, you need to have conceptual certainty. And one of the ways in which you have conceptual certainty is to have a complete list of beneficiaries. And it was held in this case that a trust did exist, but did exist without the need for there to be this complete list, as distinct from the test which requires a complete list. In this case, it was held that a trustee with a duty to distribute, particularly among a potentially very large class of beneficiaries, so for example a very large number of employees, would surely never require the preparation of a complete list of names, which anyhow would tell him little that he needs to know. So essentially it was held that the idea of a complete list would be a moot point in relation to the distribution of property in this particular trust instrument. Compare this to the Rebaden case from 1973, so slightly afterwards. Again, this is a follow-up case from the previous slide. And the question in this case was whether or not the inclusion of the, quote, relatives of the employees was sufficiently certain to qualify the certainty of objects and therefore qualify the creation of an express trust. It was held that upon application of a class approach compared to a complete list approach, we actually get three different answers. According to Lord Justice Stamp, a strict and literal application of the class test ought to be applied. And what this means is that the approach is satisfied when you can say of any individual whether or not they are a member of the class. So this is a strict and literal approach application of the class test, and it simply requires you to be able to pick out an individual and be able to say whether or not that individual is a member of the class. And if you can then satisfy that, then you may be able to satisfy the sufficient certainty that is required for the certainty of objects. A more moderate approach was taken by Lord Justice Sachs, who argued that the claimant should be able to prove they are within the class. So rather than looking at an individual and saying that they are making a strict and literal interpretation as to whether or not they are in the class at the time, Lord Sachs says that it could be the case that the claimant should be able to prove that they are within the class. There should be a certain amount of leeway and discretion given to a claimant in order for them to be able to prove that they are part of the class, and therefore satisfy the sufficiently certain for the certainty of objects, and B, actually get a benefit under the trust. And then Lord Justice Magar suggested that the application of the, quote, substantial numbers test ought to be applied in this case. And what the substantial numbers test suggests is that the is or is not within the meaning of the trust does not imply that any person is or is not a member of the trust itself. This is a relatively interesting case, and it does essentially spit out 3 different approaches to looking at the idea of sufficient certainty for the purposes of a discretionary trust, and we will do some more lessons on this in the future, looking at even more cases in and around this area.